Welcome to Unit 2, Researching the Law. Legal research is an art as well as a skill. It calls for judgment and creativity, along with mastery of a set of tools and techniques. Each research question will have a different starting point, process, and conclusion. Every research project will include false starts, dead ends, and revisions. There is never one right path. Researchers choosing different paths for the same research question may be equally successful. Legal research is never finished, but the experienced researcher recognizes when to stop. The starting point of research depends on the nature of the issue, how it is presented to the researcher, and the researcher's experience. The starting point for research may be a fact pattern, a subject, an issue, a case, or a statute. At the outset, determine if your research will be exclusively in case law or if there are statutes or regulations that should be explored. Determine whether your research will be primarily in federal law or state law or both. Research often begins with a fact pattern. You might be given an on-point case or statute, but seldom will the facts of your research question fit squarely with the facts of other cases or the language of the statute. A client relates a narrative for which he feels wronged, but has no legal theory to justify or deny compensation. This is when your legal training will come into play. It is extremely difficult for someone untrained in the law to translate a fact pattern into a legal theory of recovery or defense. So let's look at a fact pattern. Ronnie, a salaried driver for the Acme Corporation, was unloading goods at a customer's loading dock. Ronnie and the customer began to argue about whose duty it was to move the goods into the store. Ronnie shoved the customer. The customer fell and was injured. The customer is suing Acme for compensation for his injuries. Acme employs you to represent the corporation in the upcoming negotiations or litigation. The case is filed within the jurisdiction of the state courts of Trinidad. The facts must be translated into a legal issue or issues. This is one of the hardest part of legal research for the beginning researcher. Legal resources are seldom organized by facts. They are organized by legal theory. You will need to identify terms of art that might apply to this situation. You will need to learn the black letter law, statements of principles that govern the particular area of the law. Black letter law will give shape and limits to your research. The parameters of your research may later have to be broadened, tightened, or shifted, but it is reassuring to start out with a map of the area you will be exploring. Your thinking about the legal issues presented by a particular set of facts is likely to change as you learn more and more about an area of the law. Just remain flexible. Once you are familiar with the relevant terms of art and black letter law, you should be able to articulate your issue more precisely. So what do you use? How do you research? Do you use print or online? There is no right or wrong way to begin your research. In the past, researchers had no choice but to conduct legal research in print resources. The last few years have witnessed the introduction and tremendous growth of a powerful alternative, online legal research. Neither is the better method. One might work better than the other in this situation. You wouldn't know until you get started. In all likelihood, you will move back and forth between print and online resources during the research process. When confronted with an unfamiliar area of the law, many researchers find it easier to use print resources such as legal encyclopedias, restatements, and practice guides to get an overview, set parameters, learn the terms of art and black letter law. Book materials have a satisfying way of organizing and limiting research. They naturally set boundaries within the law that the seemingly endless and seamless materials of online legal materials cannot provide. Book materials can impart a sense of orientation, the feeling that you have found what you need to get started. One exception to the generalization that print resources are often the best place to start research is when the case is dependent on a particular detail. If the case rests on the fact that the vehicle involved was a farm tractor, standard print indexes and table of contents will not be organized around farm tractor cases. A full-text online search for farm tractors and injuries may retrieve cases that can be the starting point for research. You might start with a well-respected secondary source, such as a treatise, law reports, a legal encyclopedia. Law school casebooks, with their emphasis on related but seemingly contradictory cases, are designed for instructional purposes. They are not efficient research tools. Published study outlines often do not contain the clear analysis of contradictory outcomes needed for a full understanding of the issue. The print products listed on the previous screen are secondary sources. Secondary sources are written by legal experts. Secondary sources lay out general principles of law along with exceptions and variations to that law. Secondary sources are a source of citations to primary law, such as cases, statutes, and regulations. Secondary sources may be cited to support a legal theory, especially in an emerging or rapidly changing area of the law where there is no primary law available. Once you have found a secondary source or two that you trust, check the index and table of contents. Many indexes are designed with entry words that allow a researcher unfamiliar with an area of the law to find the appropriate sections. The hierarchy of the materials listed in the table of contents will help you move from general to specific issues. So what are you looking for? Terms of art that apply to the facts. You are looking for a statement of the generally accepted principles of law, often called black letter law. You are looking for enough understanding of the broader aspects of the issue to set parameters for your research. You have found relevant terms of art and black letter statements of the issue, which enables you to determine the focus of your research. The fact that the assault was an intentional act and whether the act was in furtherance of Acme's business and foreseeable will be important considerations. You can now lay out the broad parameters of the issue and state the issue using appropriate legal terminology. You must persuade the court that Ronnie's intentional act was outside the scope of his employment. You must also anticipate the arguments of your opponent. Let's look at the issue. When Ronnie assaulted the plaintiff, was he acting within the scope of his employment with Acme? That's your issue. Now there is a two-step determination. There are two questions that will help you determine if Acme is liable for Ronnie's actions. Was Ronnie an employee at the time of the accident? Was Ronnie's conduct within the scope of his employment? The second step will be the focus of your research, as there is no issue as to Ronnie's employment status. Controlling statute. Now you are ready to explore employee vicarious liability in more detail and retrieve relevant primary law. The next step is often searching more detailed secondary sources or case law. But another option is to see if a controlling Trinidad statute exists. Because you now see your term of art, which is vicarious liability, and that will help you to determine or find if there is any controlling Trinidad statute. You want to expand your research. Having found the controlling statute, but being unable to efficiently utilize the large number of annotations, you might turn to secondary source that will analyze and synthesize your issue. At this point, you have two choices. You could use the terms of art and the language of the black letter law and go to a print secondary source and use the table of contents and index to focus your research. Or you can go online and search for documents containing the terms of art. Going online primarily can be an expensive choice, especially if you have easy access to print resources. The next step is to read the full text of cases that seem most relevant. The critical and often very subtle factors that influence a decision must be isolated and analyzed. This can only be fully accomplished by a thorough reading of the complete text of the cases. Some cases might seem to be contradictory, but you should be able to detect a trail of consistency drawn from subtle factual distinctions among the cases. You should read opinions that have imposed liability on the employer and opinions that have not imposed liability on the employer. Several of the cases retrieved set forth factors a Trinidad court should consider when deciding whether to hold an employer vicariously liable for the intentional acts of employees. 1. Whether the tortious act was primarily employment-rooted. 2. Whether the violence was reasonably incidental to the performance of the employee's duties. 3. Whether the act occurred on the employee's premises. And 4. Whether it occurred during the hours of employment. You've done the research and you feel confident of your understanding of the issue. You have isolated the most relevant articles, cases, statutes, and key numbers that were found by different methods of research and which cross-reference one another. You've carefully read and analyzed relevant Trinidad law. You've ensured the cases you are relying on are good law. You can support your position with references to primary law and secondary sources and counter the arguments likely to be presented by opposing counsel. But you need to know when to stop. Here are 3 things you should consider. The loop rule. When you start to see the same documents and citations over and over, you should probably realize you are done, especially if you have used the research products of more than one publisher. The economic analysis or diminishing return rule. When you are investing more in your research than you are getting in return. The Zen rule. When you have been working in an area of the law for a long time, you will be so familiar with the primary and secondary law, you will have become an expert and will know when to stop. Now, you can write a persuasive memo or brief. This was just one potential path to the legal research process. Every research process will differ. You could have competently explored more or less resources depending on what is at stake and the time and money available. You'll be a successful researcher if you understand how to use the many resources that are available in a flexible and efficient manner. This is the end of this presentation. Thank you for listening.